Okay. I apologize to everyone for getting started late today. We had mechanical problems with our electronic recording equipment, and that delayed us about a half an hour, and we've made up about 20 minutes of that time, or 15 minutes of that time. But this is the time we had set for an evidentiary hearing regarding a petition to enforce child support and medical expense reimbursement in the matter of Lisa and Robert Gaudreau, Family Court Case Number 2001-004409. And I would ask counsel who is here for petitioner, former wife, to identify himself for the record. And then I would ask a husband who is representing himself in these proceedings to confirm his presence for our court record here this morning.
Thank you, Your Honor. James Viles, appearing for petitioner who's present to my right.
And sir, you are?
Oh, sorry. Robert Gaudreau.
Welcome. I did receive from Mr. Gaudreau on July 6th a motion for continuance, which it's motion for continuance, motion for sanctions for failure to comply. And I don't know if I formally denied that or not, but that was not presented to us until 4 o'clock p.m. on July the 6th. We didn't receive it until then, and I'm certainly not going to continue something if there were grounds to continue the matter, though that should have been set out weeks or months ago. I also did note, and I hadn't even been aware of it, you are requesting a change of judge, sir, for what reason?
Sir, because I filed, what you're talking about a month earlier, too, a motion for continuance a month earlier, and on June 7th.
Okay.
And I was concerned that I'm getting their disclosure so late. I didn't have time to review anything. I just felt like there was the fact that I'm going pro per. I wasn't taken very seriously about what I was filing.
Okay. I don't think that there's, if there was any a sworn affidavit showing some type of extrajudicial bias on my part. I don't know Ms. Gaudreau. I don't know you. But I don't see any, and you've appeared in front of this court before previously, have you not?
Yes, sir. I have appeared. I don't think there's been a ruling made.
Well, it doesn't matter. If the parties, if you and your wife have been in front of me for a pretrial management conference of any kind, which I believe you were at our return hearing,
Well, Your Honor, you'd actually signed an order modifying the parenting time and child support in 2008. So any request for change of judge?
There's not a right to change of judge as a matter of right, and I'm not offended if somebody files a timely notice of change of judge. But once I have entered a ruling, conducted a hearing, or even had a pretrial conference, there's not a right to challenge a judge except for legal cause. And a legal cause would be a requirement of a motion or petition for removal of the judge for legal cause that is verified and under oath. And I don't believe that has occurred here, this motion for, wait a minute, let me back up. Let me ask you this, Mr. Viles. I do have this motion. I do have this motion for change of judge for cause, an affidavit. The problem is the affidavit isn't signed as an affidavit. It makes allegations, and it's not subject. It wasn't filed or signed under oath, subject to penalty of perjury. It was just signed and dated yesterday's date. Sir, on what basis do you believe that this judge has any bias one way or the other in favor of mother or in favor of you, against mother, or against you?
Sir, as I said, I filed a motion to continue on June 7th, as well as a concern on this motion put in front of me regarding disclosure that was made. There was no real disclosure made on her finances. The fact that you didn't address that, and I called down to your office and had asked about it, and then it was still not addressed, and I was pretty frantic. I was getting nothing from them, and then I get everything.
Let me ask you a question.
I thought it was more of a pro-per bias, sir.
Okay. 90% of the cases, probably 95% of the cases I have at least one party without a lawyer, and over 80% of our cases have people with no lawyers. And I think if you check my records, I rule against or for the parties, irrespective of whether they are or aren't represented. My real question, though, is why you waited till yesterday to file a motion to continue and a motion for change of judge, rather than doing it in June or
because
earlier than that.
The cause, as I pointed out, Your Honor, was that I didn't feel you were addressing anything that I was sending down to you.
Well, did you before I will consider a disclosure or discovery request, there's a requirement in the rules. Did you call Mr. Viles and attempt to meet with him or talk with him by telephone to find out what it is you're missing?
Yes, sir.
And what is it that you think you need? Because this whole proceeding is based essentially upon allegations that you have failed to pay spousal maintenance and child support. And the records of the clerk of this court are going to be the critical evidence in this case.
Sir.
What is it that you didn't have that you think you need to show me that you've paid what the records show you haven't paid?
Because we've given him.
I thought you were asking me a question.
I am.
Sorry.
He just
Okay. Mr. Viles, please let the gentleman talk.
I'm sorry.
Go ahead.
The disclosures that they gave me on their financials, okay, it's my allegation that the amounts that are owed, even though they're shown owed in the system, are incorrect because of false filings by the petitioner, the mother. She has withheld. I have evidence that shows that she has withheld information to the court and filed false information with the court, which would have changed my child support completely. In fact, it would have reversed the child support, sir.
Question that I have is that if you felt there was a basis to modify child support or spousal maintenance, you've been before this court more than once since 2001.
Yes,
why didn't you file a petition to modify child support or spousal maintenance?
Sir, I have done so in the past, and I did win a modification where she appealed. We went to court for over a year over that appeal, and she won back based upon some of the evidence that she presented as far as income, which was incorrect, and I can show that.
Do you understand, though, that because there wasn't a petition for modification filed, whatever orders of this court were entered previously, because they weren't appealed or they were appealed and affirmed,
yes,
I cannot modify child support or spousal maintenance unless a petition to modify is filed. And then the modification can be effective the first day of the first month after that petition. The only thing I believe currently pending in front of me is mother's petition for enforcement, and we would not be reviewing old orders of this court.
I have filed for custody of my children as well, Your Honor.
Is that pending for today's hearing?
No, I just recently filed.
Filed it yesterday.
Okay. And that's something that can be heard, but right now that's not before the court. The only issue before this judge is whether or not you have continued to pay the prior orders of child support and spousal maintenance. And if there was a basis to modify those last week, last month, or last year, then you needed to file a petition to modify child support and or spousal maintenance. And I cannot lawfully review, even if mother presented false information right now, I can't review what was already decided when the parties had an ample opportunity to engage in discovery and disclosure previously. Yes, sir.
Sir, it's not spousal maintenance. It's unpaid. It's non-covered medical expenses, which are suspect. I mean, it's not. So it's not spousal maintenance. It's support and supposedly non-covered medical expenses.
Okay.
And what I'm getting is things that are. I mean, like I said, and I was trying to ask the court for help for the continuance because I'm getting things going back 10 years.
Well, the only medical that I would consider awarding now is probably stuff from the last 6 months or the last year. And mother's required to provide you under the guidelines with statements of those charges within 6 months of receipt, and you're required to pay her within 30 days. I don't know that Mr. Viles is going back years and years, and I don't know that he can. Mr. Viles, how far back are we going?
We were going back on the 2007 for the orthodontics. Children have had braces, both of them, for several years.
And did mother present father with receipts or bills and invoices promptly upon receiving or paying those bills?
She's going to testify that she did.
That's fine, and father can testify that he didn't get them. But, sir, have you known who these doctors are and who these dentists are?
Yes, sir.
Any reason you haven't talked with them to find out whether or not the charges were legitimate and whether mother or not paid them?
Sir, there have been other hearings where we have discussed this in the past. If you look at the 2004 and 2005 hearing, they did not allow the orthodontics in there. She tried to, at that point in time, go after them too. She's now just, and to say that they haven't, the first thing that they gave me goes back to 2002 as far as what they're trying to present to this court, not 2007.
Well, why don't you let us do our evidence?
Okay, well,
The only this is not the right. That's why I won't. I don't want them to do their evidence. It wasn't applied in time either.
Well, question I have of you, Mr. Viles,
yes,
is whether or not I need to do anything with respect to the motion for change of judge for cause. I subjectively don't believe that there's a scintilla of evidence to support a bias on the part of this judge. If I'm going to be biased, it's going to be based upon what the evidence shows. And that's not bias. It means deciding the case for or against a party. Both parties can't be right in these proceedings. Father either does owe or doesn't owe for child support and does or doesn't owe for unreimbursed medical expenses, and that's the evidence dependent. What do I do with this motion that was, in my opinion, filed for no other purpose than further delay? But when a motion for a change of judge for legal cause is filed, I can't decide that issue or not. And I don't want to be penny wise and pound foolish. My inclination is one to suggest that this, even though it says affidavit of grounds in support of change of judge, it's not up to me to decide whether those allegations are frivolous, which I believe they are, or are meritorious, which they may be, but it isn't an affidavit. There isn't a document attached stating, the only thing is a certification that the matters were mailed or delivered to you, Mr. Viles. There is not an affidavit. This isn't a sworn statement, so it doesn't meet the requirements of the rule. But I also don't want to end up getting whatever I do, whether it's in father's favor, mother's favor, hopefully it'll be a lawful decision. I don't want to get it thrown out. I don't know what your feeling is.
Well,
and clearly, if I were to delay these proceedings, allow the motion for cause to be heard, if it's denied, I'm going to order that father pay 100% of mother's attorney's fees incurred for your time here today. If the change of judge is granted, then I'm no longer involved here. But it would have to be for cause and not for any other reason. And I don't think, it's not up to me to decide whether it's for cause or not. I can tell you, though, that it's not supported by affidavit.
Well, and I agree with that particular. Well, look, first of all, we believe that all of these motions are being filed in desperation so that you don't hear the case today because he is in contempt of court, and we think he should go to jail because he's just outright refusing to pay any support or any of these expenses. And so, again, desperate attempt, saying that you're biased suddenly the day before the hearing is definitely a deflection tactic. It wasn't done properly under the rules, as you've noted. It's untimely. You come to court, you file a motion less than 24 hours before a hearing to have a judge removed based on bias. That prejudices my client in the sense that we're here today, and if you feel like you have to continue this again, she's going to incur more fees, but he's not going to pay. You can order fees, but we don't expect him to pay them. We would like you to go forward today, and whatever the outcome of that, what I ask you to do is reject his motion based on technical grounds. If he wants to refile it, he can do that. You can do the hearing today, and then if there's some bias found, then we can deal with whatever decision you make today. But I don't think there's going to be any. There isn't one, I agree, scintilla of evidence supporting any bias claim. And I'd also point out that, as I did before, that Mr. Goodrow signed a stipulated order modifying parenting time and child support that you entered on July 22nd, 2008. So he didn't object to you then, and he hasn't objected to you since this matter was filed and served on him.
I have, Your Honor.
But my client's concern is this is what he does every time she deals with him in court, is these delay tactics, filing things at the last minute, serving things the day of the hearing.
Your Honor.
And you're just going to give him what...
I stopped him when he interrupted you, so please let him finish.
And you're just
okay,
going
but he's going to go till he's done.
Oh, okay.
And he's just going to get what he wants if you send this to another judge to decide on whether you're biased or not, if he gets a continuance. So.
Yeah, hold on just a second. Well, number one, this motion for change of judge is not supported by affidavit. Number two, an affidavit shall be timely if filed and served within 20 days after discovery that grounds exist for change of judge. No event occurring before such discovery shall constitute a waiver of rights to change of judge based upon cause. Question I have, sir, is what occurred all of a sudden today as opposed to 20 days ago or 30 days ago or 60 days ago? We had a return hearing in this court that set this for an evidentiary hearing today, and you didn't express any concerns for bias at that time.
Yeah, sir, I was waiting and waiting till, the last thing I wanted to do was exactly what I felt that I was compelled to do because of the, like I said, I had filed on the 7th of June some papers and such that were never addressed. It addressed exactly the type of concerns that this man just went off on and accusing. They didn't get anything to me as far as disclosures. It talks about that. They were 20 days late. He files a thing with the court saying a few days late, no big deal. They were 20-something days late with their financial affidavits, which gives me no time at all. And then what they give me is totally incomplete, sir, and I need that kind of information in order to actually protect myself.
Well, let me ask you this. What I don't understand is mother's complaint simply, she's not seeking a modification of child support. She's not seeking anything that really even requires an affidavit of financial information, because the issues before this court are really whether or not you have paid your support and done your medical reimbursement, and I have to decide whether my mother's entitled to it. I find that the motion filed July 6, 2010 and received by us at about 4 p.m. yesterday is untimely. The allegations in it are ones that father knew or should have known of at least 20 days before these proceedings or a week or two ago. And he waited until yesterday to file both a motion to continue and the motion for change of judge. I do not believe that I know the parties at all. I've seen them before. I am not biased for or against either one. I have to hear the evidence. And the evidence seems to me to be what mother has or hasn't received, somewhat based upon her testimony, but primarily based upon what the records of the clerk of the court demonstrate. And her financial wherewithal really isn't an issue here. On the other hand, it's father's financial wherewithal that is an issue, because if he hasn't paid, then I need to determine whether or not his non-payment has been as a result of his misfortune or unemployment, or as the result of a willful disregard of court orders.
May I interject?
Yes.
The reason that we're here, my belief is discoveries that I had made prior to this filing on.
That's not why we're here.
Excuse me.
That's not why we're here. We're here in our petition.
Please let him talk, Mr. Viles, and then we're going to get started. I'm not going to continue the case. I'm not going to send it over to our presiding judge for a review of the motion for cause because it's not supported by affidavit, and I believe it's untimely. But go ahead, sir.
Sir, if it makes, the reason that we are here is actually more to do with my discovery of the financial dealings of the plaintiff, and where this is her way. She knows I have nothing, Your Honor. I'm living in the back of an office. I have no assets. I listed everything in the world that I have when I did my financials. She knows I haven't anything along this line. What this is meant to do is prevent me from filing, which I have told her I was going to do, as I was gathering evidence, and I found substantial evidence that shows that she basically stole from the community assets a significant amount of money.
All right. Here's where we're at, sir. This is a 2001 divorce case. And the parties had an opportunity before the divorce decree was entered to engage in discovery and disclosure. And if they didn't properly disclose or things, they've had, since the time that the decree was entered, 8 or 9 years to file a motion for a new trial. If there was newly discovered evidence that reasonably couldn't have previously been discovered. Father is contending that there's newly discovered evidence that couldn't have been previously discovered, and in the same breath telling me he doesn't know what it is.
No, I know what it is.
Okay, well, sir, we're not relitigating your divorce. It's long over and done with. You're sophisticated enough, extremely sophisticated, by virtue of the pleadings you filed in this case, to have filed a petition for modification of custody or parenting time, if you felt that appropriate, or to file for a modification of child support if you felt that you really have nothing. So the real question is if you have nothing, is that the result of willful unemployment on your part or the like? I'm not going to hear any further argument. I'm going to go ahead and ask Mr. Viles to call his first witness. You'll present whatever evidence you wish to present, and Mr. Goudreau will have the right to cross-examine Ms. Goudreau if he wishes to do so. And when we're done with her testimony, he'll have the right to take the witness stand under oath or affirmation and tell his story to the court of why he has not made payments or why he should not make certain payments. And he can tell me under oath the things that he believes mother has withheld from him or has failed to timely disclose. And as I said, her current financial situation is really irrelevant because there isn't a modification, a petition for modification pending. Whether or not she has incurred these medical bills and whether or not she did so after consulting with father before incurring those expenses are all issues up in the air. We're going to get started, and I'm going to let you, through your client, counsel, proceed in explaining to me whatever needs to be explained, subject to cross-examine and subject to any controverting testimony.
Your Honor, before we begin, though, I do have expenses here that my client is requesting that are over a year old. If you're not going to consider them, then
Well, I'll hear the testimony. I don't know whether or not, I don't know what she did or didn't do, and I don't know whether that request is timely or not. I'll allow you to present whatever you think is appropriate, and then you can argue to me whether or not it is reimbursable. But normally, a request for reimbursement with supporting documents needs to be made of the other party within 6 months of the charge being incurred, and then needs to generally be paid within 30 days.
Okay.
But I'm not ruling anything out. I'll let you present what you think is appropriate. Okay. Then I'll hear the parties' arguments, and if we need to brief any legal issues, we'll do so.
And Your Honor, one other question I had. You had, at the return hearing, had ordered the family conference center to do a arrears calculation for this hearing, and a week ago when I was preparing for the hearing, I noticed that we didn't have one yet. I'd called over to Greg, your assistant, and let him know. And I don't know if
I'll ask,
Did you get one?
we'll send an email or make a call back to Greg, because we did request that the Family Court Conference Center prepare a current arrearage calculation and deliver it to the court. I don't have it amongst my paperwork this morning. Let me see if we can.
And as of a week ago, they hadn't done it. So I think usually if they do have it, you usually have it when we start the hearing. You probably don't have it yet.
I probably don't have it, but we'll see if one has been prepared, and if not, why not? And we may be able to have somebody. Did Greg talk to them though? And I mean, I don't know if they can run it now or not. Okay. Go ahead with what we have, and if I need to wait for that before I rule, I will. But
did you want to swear the parties in first, Your Honor?
If the,
'Cause I'm gonna be calling them both.
I'd ask Mr. and Ms. Goudreau to stand, and we'll administer an oath. If either of you prefer an affirmation, we can have you affirmed after the other party has been sworn. If you're willing to take an oath, though, I'd ask you both to raise your right hands.
You and each of you do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you.
Sir, I would like to draw to the court's attention that I did file an objection to all of their witnesses because of timely filing, all their witnesses and exhibits because of timely filing.
I believe that the only witnesses that are going to be called are the two of you, so there aren't any outside witnesses. And the only affidavits, I mean, I have mother's affidavit of financial information. Even if it's late and it was required to be filed, I don't need the information contained in it. There is, plaintiff has an annual payment record. We have both parties' affidavits of financial information, and 2 emails and a financial agreement that the parties apparently made. And the two of you may be seated. I'm going to go forward. If there's a particular exhibit that is getting discussed and you want to make an objection to it, I'll hear you out on that. But it doesn't seem to me that there are volumes of documents being presented to this court, and I would have expected on the medical expenses that mother has provided father with notice of those expenses. But we'll see. Go ahead, Mr. Viles.
Thanks, Your Honor. I'd like to call my client first. Then.
Ms. Goudreau, I just need you to take the witness stand, and you just need to make sure that that microphone is in front of you.
Doesn't matter which chair.
Just that one right there. And the microphone stand slides, but you just need it looking. That should work fine. Counsel, whenever you're ready.
Thanks, Your Honor. Please state your name for the record.
Lisa Goudreau.
Okay, and Lisa, you are the petitioner in this action, is that correct?
Yes.
You have 2 children with Mr. Goudreau sitting behind me, is that right?
Yes.
Can you tell me the names and ages of your children, please?
The oldest is Nicole Goudreau. She's 17, and the youngest is Natalie, and she's 15.
And, well, this is not the first petition to enforce support that you've ever filed, is it?
No, it's the
Okay.
second.
And this current petition that you filed on or about, or in or about February of this year, is that correct?
Yes.
And you're requesting the court to enforce the child support order, is that right?
Yes.
And to order Mr. Goudreau to pay his share of the unreimbursed medical and dental expenses that you've incurred
Yes.
for the kids? Okay. Let's start with the last order. So the most recent order was signed by the court July 22nd, 2008, related to child support. Is that right?
Right.
Okay. And that order states that Mr. Goudreau is to pay you $200 a month as current support, and then together with an arrears payment of $200 a month.
Correct.
So the total is $400 a month. Is that right?
Correct.
Okay. Then it also states the unreimbursed medical and dental expenses shall be paid 50% by mother, 50% by father, at least as of July 22nd, 2008. Correct?
Yes, that was also in our divorce decree as well.
Okay. Same percentages?
Yes.
Okay. Now, since this was entered, has Mr. Goudreau made any payments, child support payments?
My recollection is maybe 3 since that time.
I'm going to hand you what's been marked as Exhibit 2. That's the annual payment record from the clerk of Superior Court of Maricopa County.
Okay, there's 4. Okay.
Have you had a chance to review that before?
Yes.
Okay. That shows, well, let's see what page you want. First page shows
This is all
the
of,
payments made since
2008, 9, and 10.
Okay. So it appears he made 4 payments of $397.75 in 2008, correct?
Correct, that's what it shows.
Didn't make a payment in November, though, correct?
No.
Did he make a payment in 2009?
No.
According to that, it says he did not. Your Honor, I'm going to ask that Exhibit 2 be admitted.
Is there an objection to Exhibit 2? It'll be admitted.
Now, so did he make a payment at all for, for 2009?
No, nothing.
So he made a payment for 2010?
Nothing.
Not a dime?
Not a dime.
Okay.
Nothing. That's the best he can do.
All right. And have you contacted him about paying those orders?
I've contacted him by email. I've asked him verbally, on the phone, by text. I've asked him numerous times when he can actually help support his children.
What are his responses tend to be?
Always the same response. I'm doing the best I can. I guess his best is nothing.
I'm going to hand you what's been marked as Exhibit 5. This is a string of emails, is it not?
Yes.
What are the dates of the email?
I object to it.
You know, I forgot my
Well,
cheater.
let me just have her tell me what it is, and then when they offer it, I'll entertain your objection.
I forgot my cheater, so I have to hold it back here.
That's right.
January 5th of this year.
Okay. And in that email, do you request payment?
Yes.
What's it say in the email?
Oh, goodness. I knew I should have brought my things. Which one am I looking at?
You have trouble reading?
I'm having, I didn't wear my glasses.
Tuesday, January 5th, 2010. Bob, what you think you owe has nothing to do with child support. What I owe you has nothing to do with child support. You made no payments in and before 2007, only 3 in 08, and nothing in 2009. I need you to start making payments immediately. $400 per month is ordered. That's what you asked him to do, right?
Yes,
On January 5th of this year.
yes.
His response is what here? Says, let's see. If you pay me the money you owe me, then I can catch up on the support. If you pay me what you stole, I can retire. I've had enough of your crap. See you in court. Is that what he said to you?
Yes.
Okay, and that's January 5th. There are a couple of other things, but Your Honor, I'm going to ask the Exhibit 5 to be admitted.
And sir, what's the basis for your objection?
It wasn't disclosed. None of this was disclosed in near time frame.
Let me ask you a question. When did you disclose the exhibits that you were
I
going to?
probably sent him this one about a week ago. It wasn't recent, but it is an email that he should have a copy of.
Sir, it was less than a week ago.
Okay. Let me assume it was just yesterday. Are you contending that you never received the email and that the response to Mother's email wasn't written by you but somehow was generated by somebody other than yourself?
I'm saying that because he didn't disclose it in a timely fashion, I haven't had a chance to do any kind of rebuttal to that email. That is one piece of an email in a system of emails that we have.
Well, the reality isn't what was said between the two of you anyhow. It's not going to – I'm going to admit Exhibit number 5 because both parties should be aware of the emails that they exchange with one another. And just as Mother is bringing these in, Father could have – these aren't pieces of evidence that were exclusively in Mother's care, custody, or control. And if they're incomplete, I'll entertain Father's explanation. But the real issue is whether he has or hasn't paid the court-ordered child support in whole or in part, and the reasons why he has or has not paid. Go ahead.
Thanks, Your Honor. Are you asking the court to find Mr. Godot in contempt of the child support order?
Yes.
You've had an opportunity to, well, do you believe he has the ability to pay the support?
I believe he has the ability to pay. He was vice president of a national corporation, international corporation, making hundreds of thousands of dollars a year, and now he can't do anything?
How long ago was that?
I think he was, he retired from that back in 95, I believe.
Your Honor,
That's fine.
I can't.
Again,
You know, he has
he'll
to
have
be-
quiet, please. He'll have an opportunity to question Mom, and he'll have an opportunity to testify if there's an objection. Mr. Goudreau should state the objection, but he shouldn't make any comments with respect to Mother's testimony or questions asked of Mother. Go ahead.
Thank you, Your Honor.
My belief is he doesn't try.
Okay. And again, and I'm sorry, I couldn't hear you over Mr. Goudreau's comments while you were talking, but how long ago was he making that kind of money?
I think it was like 1995, he was making that kind of money, and then he went off and had our own business in chiropractic. And so we had our own business there till after our divorce. And then after our divorce, he just quit working it or something. I don't know what happened to it after our divorce.
All right. Now, one of the other issues in your petition was unreimbursed medical and dental expenses. Do you recall that?
Yes.
And attached to the petition as Exhibit C specifically sets out how much you've had to pay for, looks like orthodontic care,
What exhibit number you?
dental. I'm just looking at the
Okay.
initial petition.
He's been aware of our girls under orthodontic care since 2001.
Let me ask you that. So is that a majority of the expenses that you're requesting?
Yes.
Okay. And is that for both children?
Yes.
Now, the court had indicated that one of the requirements in requesting these expenses is that you give him notice of those expenses. So let's talk about that. Have you been giving him notice of these expenses as you've incurred them?
No, I haven't been giving him as I incur them, but he knows of them. They're aware of them. I've asked him for them on several times, on several occasions. He denies me every time. It just feels like a futile fight to keep asking him, but I haven't.
Well, have you given him the invoices?
I have well, they didn't give me copies of invoices. They've never sent me a statement, but I've given him.
Tell me what you've given him.
I've given him copies of my database. I keep everything in my computer at home, and I've given him printouts of when I make the payment. I've requested him to make the payment. He knows I'm making the payments. So I haven't ever gotten an invoice from the doctor. And it's only been for orthodontics. Our children, thank God, are very healthy, so there's not much for medical. It's almost all orthodontics.
I'm going to hand you what's been marked as Exhibit 6. Tell me what Exhibit 6 is.
The financial agreement from the,
Well, just, what is that group of documents?
oh, okay, these
Like-
are copies of contracts and expense sheets of payments that I've made on behalf of my children, our children.
And for the orthodontic, isn't it true that the orthodontic billings that you have in there go back to 2007?
Yes.
Tell me who they've been. Now, when you say orthodontic, tell me what kind of services that have been rendered for the kids in that regard.
Nicole has been going through complete reconstruction of her face with expansion in every direction. They've had to widen her palate by over an inch in width. She was near facial surgery, so they went around it and did all the expansion. She's had braces, she's had retainers, she's had x-rays, and Natalie has not been as severe. She hasn't been under care as long.
Well, what's the name of the orthodontist doing the work?
Dr. Brigham, Gary Brigham.
Okay, where's he located?
He's in Scottsdale.
Has Mr. Godot is he aware that that's been occurring?
Sure, he's brought them to appointments in the past.
Okay. I mean, did he ever object to the fact that these expenses were being incurred for the children?
No.
Never told you he didn't think they needed braces?
Nope.
Ever tell you that he never thought he needed to get a second opinion about the issue?
Nope, in fact, for a short period of time, he had insurance coverage, and he had Natalie start care with a different doctor that I didn't like, but he didn't finish the care, so we finished it with Dr. Brigham, who is currently taking care of our older daughter.
All right. In that group of documentation, are there not invoices? Well, is there not a print-up of what you've paid Dr. Brigham for both children?
Yes.
And the total of the expenses from 2007 to present is what?
2007?
Back to 2007. What's the total of the orthodontic?
Total just for 2007 to
No. From that date to present.
Okay, from 2007, August 2007 to current, right?
Right.
Okay, $5,008.
Well, isn't that just one of them? That's one of them.
That's one of them, yes. And then Nicole was almost done with hers, so I'd already paid hers off. So she was only $228 left on her treatments.
Okay, and then there was one other invoice in there.
Yeah, this was prior to 2007. It was.
No, there was another one.
Your Honor, may I interrupt you just a second?
Yes?
This one? Okay.
They're going through the paperwork that I this morning, actually. I only got this yesterday, and I had filed an objection to them even bringing up, and they're just using, I mean, I haven't even got a chance to review this paperwork.
Mother contends that she has sent you these printouts and summaries previously or before, as she was incurring these expenses. Let me ask you, how have you kept him notified regularly as to what the expenses are?
Primarily verbally, Your Honor. I haven't been consistent of sending him copies because he's aware of the charges. He's aware of the contracts. He's aware of the treatments.
And how often do your children go, like, in this orthodontic work? Do they go weekly, monthly? How often do they?
Varies depending upon what phase they're in and what kind of treatment they're incurring. When they were going through expansion, it was more often, and now it's in braces, but they're going like every 3 to 6 weeks.
Isn't the total of the orthodontic $6,751?
Yes.
Okay, and that's those 3 invoices that we looked at?
Yes.
For Dr. Brigham?
Right.
And again, I'm going to take note, but you can testify that you haven't received notice. I'm going to have to decide what, if any, of these bills are reimbursable.
And there are also dental expenses included in that group of documentation?
Yes.
Okay, for both children?
Yes, for $1,069.
Okay, and that's, what time period does that cover?
Let's see. I think this is from '07. This one's '07. These are from '07 going forward.
So from 2007 to present, those are the dental expenses?
Yeah.
And those are unreimbursed costs for, what, cleanings and?
Cleanings and a couple cavities.
Okay.
And some x-rays.
Right.
You know, preventative mostly.
Your Honor, I would ask that 6 be admitted. Father is right. There was late disclosure on that document. My client was only able to get those documents to me recently, going to the orthodontist to get a printout for all the. It was from 2007 to present, but it was late disclosure, and we don't deny that. So, but the figures should be accurate, whether or not the bills are in evidence or not.
I'm going to admit the documentation. I may end up not considering it. I don't know yet, counsel. I am concerned because it cuts both ways. Mother needs to be, whether she thinks father's going to pay it or not, you need to be giving him copies of any canceled check or an invoice or proof of payment as you're making the payments or within 6 months of making the payment or incurring the charge, and he has 30 days to pay you back. And if you don't provide him with documentation, it presents a problem irrespective of whether he has an attitude of I don't care, I'm not going to pay.
Well, can I say something? I have actually this year, and I know we didn't have it, and we haven't disclosed it, and I wasn't planning on disclosing it, but even this year, quarterly, I have submitted expenses to him. I have scanned copies of the of the payments of the invoices. I've asked him.
Are we talking, now, are we talking
Well, I'm
about
just-
orthodontic, or?
No, I'm talking about, what I'm saying, I guess what I'm saying essentially here is I've been trying just recently to make sure that I'm submitting everything to him like you're asking, and he still completely refuses to pay a dime.
Let me just ask you, when you have presented these things to him, does he pay?
No, he refuses.
And what's his,
Outright refusal. He know I can't do it.
and that's why you've just stopped doing it?
Yeah, it gets really frustrating. You know, I'm trying to raise my children to the best that I can by myself. You know, and I'm doing it by myself, and it gets really frustrating to keep asking him to help, and he keeps refusing.
And you've incurred attorney's fees today?
Yes.
And you asking the court to award you attorney's fees for having to enforce at bottom the child support order?
Yes.
Nothing further.
You have questions that you want to ask, Mom? And again, keep in mind that you will have your own opportunity to testify. I also need to just take a second. Do we know whether on the next matter, which is the return hearing, whether there was service and whether or not the other party has appeared? On the next matter, let me ask counsel, was there service? Aren't you here on a return hearing?
Yes.
Are you representing the party that was served?
We were served again with something this morning.
Okay. Is the other party present?
Yes.
Okay. Is it just the two parties here?
My client is in New York, and there was a request made for a telephonic.
Okay. And you are Mr. Newman, correct?
Yes, that's correct, Your Honor.
And because I'm in the middle of this hearing, but I don't know whether we just need to set an evidentiary hearing for you or not.
We're going to need an evidentiary hearing and probably a parenting conference.
Because
Do you want to put us, adjourn us and take that right now?
I can do that. Is he calling in, or do we need his presence for
No, we
doing
don't
it?
need his presence for this.
Okay.
Believe so.
Okay, what are the issues? Let me just call the case and have the parties come forward. If you want to step down for just a minute, you can, and then Mr. Gaudreau will have a chance to question you. But today's hearing is in the matter it is a return hearing on a petition, I think, for modification of custody and parenting time, obviously in child support, in the matter of Alicia Robato and Joseph Robato, family court case number 2008-052966. And I'm going to need you both maybe behind that microphone one at a time because the tables are cluttered. But I just need counsel to state his name for the court record.
Harold R. Newman on behalf of Joseph Robato.
And ma'am, you are?
Alicia Robato, I'm representing myself, Your Honor.
And I didn't grab the file, and I'm not going to delay to do that. So I don't know, without looking at it, who has filed the immediate or present petition.
There's a petition and then there's a cross petition.
Okay, who started the process? And what is your petition for? Just so I apologize to you for not having the file out here. But
Okay. Basically, Mr. Robato has moved out of state.
right, and I anticipated he might do that at the time of our trial. But go ahead.
So change of custody issues, adopting a new visitation schedule, which we were 99% in agreement on, Mr. Robato and myself. The other issues being he's basically in contempt of court on the community debt that you actually ordered him to pay back in February.
Well, what I can tell you is that there are no contempt sanctions unless someone does not pay child support or spousal maintenance. If they don't pay their fair share of bills, they can't be held in contempt of court, but a judgment could be entered against them. And that's only if you've paid bills that he was supposed to pay. If you have paid, if they were evenly split and you've paid more than 50% of the principal, or you've paid them in full, or they were his bills and he didn't pay them, you could get a judgment for that. He will not be held in contempt of court unless he hasn't paid child support or spousal maintenance.
Okay, and that's an issue too, but yes.
Okay. Counsel, and I'll ask you, I know that only because we're recording.
Yes. I filed a motion to dismiss and a cross petition seeking a modification of the child support. My client has been unemployed for 2 years. He was unemployed at the time the order went in. So, I mean, the salary that was imputed to him was well above minimum wage. He's making $278 a week in unemployment. He just started working again 6 weeks ago after a 2-year unemployment. So mine is for a modification of the actual child support, and we'd like to see if we can go retroactive to the original order. The other thing is that we have a hearing on child support this afternoon in front of Mendez, and the issues are still out here about whether or not child support should be retroactively modified. Also, I'm just being told now that there's some evidence out there that my client has been working, which hasn't been disclosed, and I don't want to be put into a position that I'm going to suborn perjury in a hearing. I asked if she has it to disclose it to me, and she's saying that she's going to disclose it at the hearing.
Well, there's generally a requirement that anything that's going to be used at a hearing be exchanged between the parties no later than 30 days before the hearing. The question I have, though, is what is being heard today? Is it a modification of support?
No, the modification is before you.
It's what?
Actually, to enforce, because he's over 8,000 in arrears.
Unless it's a 4D case.
It's a 40
If it's a 4D case, I can't do anything to stop
So I
it.
have to go over it.
You have to go over there, and it may, so that enforcement will go forward, but we may end up modifying support based upon a change of circumstance or a change in the parenting time schedule. But what was the basis for your petition, your motion to dismiss?
The motion to dismiss was that the original order was less than a year old, and under the statute, you can't seek a modification.
If joint custody, you technically can after 6 months.
It wasn't even 6 months at the time.
Okay. Well, bottom line, though, is I can tell the parties, if we have joint legal custody, there's going to be a heavy burden that has to be presented because I recognize this couple, and they were very dysfunctional as a couple, not as individuals, but as a couple at the time of our hearing. And I still felt that jointly.
That way, Your Honor. And unless we nip this in the bud,
Okay.
at this
Okay.
point, I believe
Well,
this is going to go on.
I don't know whether I will or I won't.
Your Honor, all I'm actually asking for, and I don't know
Is
this
the parenting time change?
is final decision-making authority, because with Joe being in New York, and I have a cell phone number, and I'm told he lives with his parents, but I've had issues with the school where they won't take it just for me.
Well, the reality is that if the parties are living separate and apart, and father is in New York and mother is in Arizona, and mother is the primary residential parent, until I change primary parenting time, if I do, then the children will attend a public school in mother's school attendance area unless the parties otherwise agree.
Right, I'm sorry, when I say school issues, I meant with my kindergartner, we had some issues, and I couldn't make a decision at school, staying in the same classroom and everything, because they said I don't have paperwork to show I can do that. So it's issues like that, Your Honor.
Well,
This is the first I'm hearing of that, Your Honor.
bottom line is I'm going to set. I don't know if we need do we need a parenting conference?
Although
Because it's
says that it's 99%, my client disagrees with that. He thinks they're far apart.
Okay. Well, is he asking that he be designated as the primary
No,
resident?
he's asking for more. Since he's in New York, he's asking for a different.
Well, I'm not going to order a parenting conference. If we're talking about whether he gets more or less access to the kids, we'll deal with that. If we have issues regarding final decision-making on educational decisions, we'll hear that, and we'll hear any request for modification of support. How long do you think we need for an evidentiary hearing?
This shouldn't be more than an hour, hour and a half.
What I'll do is, it's not going to be as soon as the parties would like, but I can find you maybe a 90-minute slot.
I'm on vacation for the next couple of weeks.
Well, if you think a couple of weeks, we're setting matters now out in October and November. We may have some dates in September. We may even have,
September is not good for me. It's religious holidays for me.
You can do September 15th, that's on Friday.
are you, I don't have the calendar.
I am going
Okay.
to be out of town.
That's fine.
It's religious holidays.
Can we just put them up in September next meeting?
Unless it's
To be honest, I mean, the
from
issues
the
on the
first week of
debt,
September to September 30th, I'm out of town for the Jewish holidays.
You won't be here during those.
I'll go back to the office.
It was still starting in August.
It seems to me that, I'll clarify right now in the minute entry, that the children may be enrolled or will be enrolled in the public school and mother school attendance area. And I would hope, unless we have issues of special education, things like that, there aren't that many decisions that should have to be made.
I had an issue last year where my 6-year-old was having issues. He was by the time in kindergarten, and I wanted him retained. And the school wouldn't do that unless I contacted Joe, and he was out of state, and it was just a big debacle. And so things like that.
But at this point in time, I would hope that we're not going to have any immediate issues. Are you anticipating any right out of the chute?
No, Your Honor.
I'll set you as early as we can when both parties are going to be.
And this must have been before I got involved, so if you send it to me, I will make sure it's expedited and the children get what they need.
Okay.
Mr. Newton, well, it's been really hard to get a response.
Let me just set the matter for an evidentiary hearing. I would encourage, if the parties are able to work things out, you can get me a stipulation and an agreement, and if you can't work things out, we'll be able to hear this.
We can try
And again, I do understand that there may be issues regarding child support, because father is, I believe, from as my recollection serves me, has a degree from a distinguished a master's degree in business, I believe, or I thought he did. But let me not guess about anything.
No.
We've got to be looking. August. I don't know if the parties would be ready by August 2nd at 3.
That would be fine for myself.
I'm on vacation.
Okay. Just October 4th at 10:30.
That's fine.
Fine. And I'm sorry, what time again?
10:30 till noon. Okay? And if the parties haven't already done so, I will order that they exchange with each other affidavits of financial information with all the required attachments no later than 30 days prior to the scheduled hearing.
I'm going to request the rules of evidence.
That's fine. We'll cross that bridge when we come to it, but thank you both.
Thank you, Your Honor.
Appreciate it. And we can get back on the matter at hand, and I would ask Ms. Goudreau to resume the witness stand. And, sir, you're going to be free to cross-examine her, but again, it's not arguing with her because you will have a chance to take the witness stand. And if you're going to question from the lectern, that's fine. If you're going to do it from behind table, you just need to make sure that your microphone is looking at you. You can hand her whatever exhibits you want to hand her. But I need you, when questioning her, to be behind a microphone. But you can hand her exhibits if you want her to look at them.
Have you seen those before, Lisa? Those canceled checks? They were filed with the court before.
What do these have to do with?
Sure.
We didn't have any exhibits marked, so I don't know.
Do we have additional exhibits, Mark?
From another hearing. I don't know what he's,
In our initial hearing, Your Honor,
These are from
Hold on.
2002?
I think it's from 2005.
What did we retrieve exhibits from? Those were previously marked as exhibits and were returned after those hearings? We're dealing with child support arrearages from 2008 forward, from 2008 forward, not 2002 or 3. Yes, sir?
in our initial hearing, Your Honor, you said that if I could show that I had documentation, I had offsets, possibly, that, and I'm asking this, if she has actually seen these. I mean, she obviously cashed the checks. And so my question to her was,
The problem is that though we can't use exhibits that were previously rejected, you needed to get them to my clerk to have them remarked. You want to ask her whether whether you've made payments to her in 2002?
These
I'm
aren't
sure.
made out to me.
No, I can't ask her whether she's familiar. I mean, I'm not going to admit the form. I didn't want to admit the exhibit. I just wanted to ask her if she actually got this money.
how did I get this money? It was
Okay,
made
you
up from Blue
can,
Cross Blue
I'll let you ask her whether she received monies at a particular time frame, and we can use those checks or whatever to refresh her recollection. I'm not going to admit them, but,
Okay, on the one page here, it says, paid to the order of Lisa Goodrow. Do you see that one?
No, I only have one in front of me. It says pay to the order of Blue Cross Blue Shield.
Oh, well, I think I thought I gave you
Blue
seven.
Cross Blue Shield,
Oh, you took them
I
back.
can't
Oh,
be
sorry,
cashing
I'm sorry.
checks.
I'm sorry, you took them back. Hold on.
The other one that I glanced at was to a carpet company.
I'm sorry, but you took them back from you. You may. That's first one.
That was money that, yeah, there was a check there for me, 2002, for $10,000
And
for a
it's
house
just-
you were gonna buy from me.
And I'm going to object to that check, because again, we're talking about a time frame of 2008 to present, and I don't know why he would be
And
giving
check
us a
the-
check.
the question I have is, Mother isn't seeking any arrearage payments for time frames back in 2001, 2002, 2003, 2004, et
Well, it would
cetera.
depend on what the calculation says, I think, too. I mean, if
Yep.
the calculation shows an
Or
arrears.
maybe, but were arrearages previously calculated?
I don't know if
They had to have been previously calculated in July of 2008, because the court is ordering $200 a month additional payments.
Well,
I'm assuming-
that was by stipulation, though. I don't think we had a calc done. I don't have one in my file.
Because I'm not going to, I don't know, was there any stipulation as to what the amount of the arrearages
No.
was at that time?
No. Parties didn't know at the time, I think, and this is how we settled the issue.
Because one of the dilemmas I have is that father's obviously entitled to credit for any payments.
Well, when was the decree was entered? I can take a minute to see. I think the decree was entered April 2002, so
Correct.
any payments before that wouldn't. What's the date of that check, Lisa?
Go ahead and ask your questions.
On that same page, if you turn it in this manner, there's another one for $10,000. Does it say loan?
I don't have that one. This one says for payment on the house.
Turn it.
Could we have some foundation, please, as to the date
What
of
date
these checks,
are
please?
these checks?
This one's dated May of 2002.
Mhm.
He had agreed to buy a house that I got awarded in the divorce. He wanted to buy the house, and this was a payment towards the purchase of that house. It had nothing to do with child support.
Go ahead.
Okay, now, in previous emails and such, have we addressed these expenses or these debts that you owe me?
I don't owe them to you.
And can I ask why you?
The objection regarding debts, why that's relevant to today's hearing?
Yeah.
Any debts that existed at the time of the divorce were subject to being litigated at that point in time. If the parties have not paid off those debts or are indebted to one another because of that, those issues aren't currently in front of this court.
This was after the divorce, Your Honor.
Okay,
This was-
but have you filed a cross petition seeking reimbursement of expenses?
No, I haven't, Your Honor. We actually had this as part of our, I suppose we got to just go to a different area because
Okay, go ahead.
you filed for a modification and you appealed the modification that was done in 2005. Did you not?
Yes.
And your appeal, didn't you go after the orthodontia payments at the time?
I don't recall right offhand, but probably. I've been asking you to pay for child support and orthodontics for years now.
Now, You did actually manage to increase the child support.
No,
Alright.
actually, the child support at the divorce decree was 600, and you got it reduced to 155.
Yes.
And then we did a stipulation 2
Your Honor,
years
I'm-
ago to 200.
Okay. You increased it from the amount they had adjusted it to based upon our incomes by appealing. Is that correct?
Objection, relevance.
It's very relevant.
Well, overruled, she may answer.
What's the question?
You managed to, upon my filing for a modification, they found that I would pay X amount of dollars. You did manage to increase that amount over by appealing the case. Is it true?
I don't recall what the actual amounts were.
No, but you did increase it, did you not?
I don't recall what the amounts were, so I guess I don't know.
I'm
I'd
just
have to
simplifying.
look at the paperwork.
At that time, you had addressed the court regarding orthodontia, and it was included in your paperwork. Did the courts rule in your favor? Did they charge me any expenses for the orthodontia, or what did they say?
I don't recall asking for orthodontia at that hearing. That was for child support modification. That's what that hearing was for, nothing else.
No,
At the time, I don't recall right offhand, to be perfectly honest, but why would I be asking for orthodontia at a child support modification?
just like you are now.
No, this isn't about child support modification. This is about non-payment of child support.
Was there a ruling made, to your knowledge, as to whether or not the orthodontia was my responsibility or portions of it were my responsibility?
There has been an order since our divorce that you are to pay 50% of all medical bills not paid by insurance.
Unpaid medical. But there was an issue of you signed a contract, did you not, that you provided to me, without my knowledge even.
On
At the
what?
time, for the orthodontia.
You knew of it. You've known of it
Your Honor,
since
she's not answering my
2001.
question, she's just coming back at me.
Well, you want to argue with her?
No.
Okay. She's answering your question by saying that you knew about it, and that may not be true. But she answered the question saying that you knew about the orthodontia before the charges were incurred.
Your Honor, we have dealt with this similar thing in the past, is what I'm trying to get to in other hearings, or another hearing at that time where she basically,
Objection, Your Honor. Is he testifying now, or is he asking questions?
Hold on.
I was just
Okay.
addressing the court, Your
Okay,
Honor.
that's fine. What you need to do is ask her questions she can answer. She's not going to always give you the answers you want to hear. So the time that you have, you may want to spend explaining to me. It's perfectly appropriate to ask her whether these issues were addressed before, whether she provided you with notice, and so forth. And she may give answers that you disagree with, and you'll have an opportunity to take the witness stand and explain things to me.
This all goes to the credibility of the witness, Your Honor, okay, which I'm going to.
Go ahead and ask your next question.
Okay. Have you ever lied under oath to get what you want?
Objection, argumentative.
Overruled. Have you ever lied under oath to just get what you want?
Not knowingly. He's referring to,
I don't know what he's referring to. He asked you a question. Don't speculate or guess. You've answered the question he asked of you. Go ahead with your next question.
Have you ever been at a hearing where the judge has stopped the hearing
what?
because of your testimony at the time regarding something?
Not that I recall.
Okay. This all, like I said, goes to the credibility of the
Don't
witness.
explain what it goes to. Ask the question.
Okay, okay, well, let me, well, I'm not good at this.
Can I ask
Okay,
a question? Can I ask a question?
No.
Okay.
Sure, hold on. You stated that you feel that I have the ability to pay you and the means to pay you what you're asking. Have you been sending me emails as of late, within the last few months, and did you not send me an email that requested $3,000 for 3 months as what you consider to be my portion of the girls' expenses?
I did send you that recently in March
Yes. Did they
for
include,
oral surgery on Nicole.
did they also include dresses? Did they include all kinds of other things with it?
I'm sure, yes, because I have these expenses. Our daughters are growing up and they need clothing.
Yes.
I've asked, so I'm asking you to help financially support your children.
Yes. Now, the thing that I got sent to me, which you guys, I assume that I tried to, or admitted into court, was went back all the way to 2002 and included school lunches and cash. Now, is it true the girls live with me and I had joint physical legal custody 50% up until 2008?
Objection, relevance.
I'll overrule the objection.
Yes, you had joint custody by the paperwork, but they weren't with you 50% of the time all the time.
Did you contact the parenting coordinator prior to filing for the custody in 2008 and a modification of support?
Okay, objection, relevance.
Sustain the objection. It's not relevant.
Is there a court order requiring that you do that?
Objection, relevance.
The issues before this court today are alleged non-payment of child support and non-reimbursement of medical expenses. I don't want to review what went on in other hearings.
Thank you.
Okay. Let me see. You stated that in 1995, when I had that business, or excuse me, when I was a vice president for the company, I had worked for that company for how long?
It changed hands. I don't recall exactly because they merged with one company and then with another company.
But
Years.
it was a gradual process, wasn't it?
Mm-hmm.
That was a yes. Go ahead.
Yes. But since that, when I got the chiropractic business, I built the chiropractic business.
We bought it.
Yeah, well, I bought one clinic and built it, and tried to build it anyway. You are aware of the difficulty that we ended up in financially at that time, at the end of our marriage, are you not?
No, I wasn't part of the business. You ran it. I was at home taking care of our children.
You didn't take care of the books for the business?
No,
You didn't
that would
file the
be, no,
taxes?
you had, remember you had.
Your Honor, I'm going to object to these questions because I think they go about beyond my examination at this point.
Well, the real thing that I need to look at is whether there are any child support arrearages that have occurred since July 22nd of 2008, and whether or not there were any medical expenses incurred after that date. And again, I'm not going to consider any medical expenses that are prior to the last agreement of the parties because that could have been addressed at that last hearing.
Well, Your Honor, they weren't, though. I mean, that order didn't
I'll talk about it
Yeah.
later, but it seems to me that when the parties reached an agreement regarding current support and arrearage payments, they could have or should have litigated anything else that might have been due and owing at that time. But I'll hear you out on it. I'm open.
It seems like I'm just locked into.
Reason we're all locked into it is because the parties had a divorce trial and findings were made. There were subsequent orders that have been issued by the court either pursuant to agreement of the parties or hearings, and we can't relitigate. The law doesn't allow us to relitigate what either was or could have been litigated at an earlier time frame.
Your Honor, when they establish things such as support, and they file affidavits of financial information, correct? I mean, in that sense. That goes to establishing the support amounts.
Right, but if there's a change in circumstance after the parties have exchanged affidavits, it's their burden to come forward to the court to seek a modification. and if they don't, then the old child support orders, too high, too low, or otherwise, remain in full force and effect.
That wasn't what I was referring to,
Okay,
Your Honor.
go ahead.
I was asking that, I mean, child support is established, of course, by the.
Your Honor, look, we have an hour for this hearing, and he spent a lot of time dealing with his motions that you've denied. Now he's just up here talking, so we need to.
Go ahead with if you have further questions of Mom, go ahead and ask them, keeping in mind that you're going to need to save some time for your own testimony.
Your motivation right now, you claim to be because you feel I need to help support our children. Have I ever told you that I don't agree with you on that matter?
The objection, these are argumentative questions at this point. Whether he should be paying or not, he should just be, whatever motivation is.
Sir, don't get all frustrated. Overrule. You may answer the question if you understood it.
I didn't understand it. My motivation is for you to help to pay your child support that you've been ordered. $200 a month plus $200 in arrears to raise 2 teenage girls by myself. I don't think that's excessive. And yes, I do that. I do expect you to pay that.
Yes. And would you expect to pay me that if the incomes were different? In other words, if we were in different positions?
Objection, irrelevant and argumentative again.
Well, one, I don't care whether she would. If you were the primary custodian of the children, or there was equal parenting time and she was earning significantly more than you, I would expect her to be paying child support to you. But right now, she's the primary residential parent of the kids, and the court has set child support in whatever amount it's been set.
Okay. We agreed on the amount of child support in 2008. Is that correct? It wasn't. You never
was a stipulation.
provided me. Did you provide me at that time with any kind of worksheet or anything along those lines?
Objection, relevance. It was agreed. Hold on. It was agreed upon. Who cares if that happened or not?
Well, I'll let her answer whether she did or she didn't, but we did have a stipulation and agreement rather than an evidentiary hearing. But you may answer the question.
It was a stipulation. There was no reason to do anything else with any kind of disclosure. If you wanted disclosure, you should have gone through a modification, I would imagine.
Did you ever threaten me, either through emails or through verbally, to throw me in jail if I didn't agree?
No.
Okay. And I just, since I owe this amount right now, and I have filed actually for for the custody of our children.
You want custody of our children?
Yes, ma'am.
Where are they going to sleep?
That's an issue we'll have to take up on another day.
They're 17 and 15.
Okay. Well, he can file for what he wants, and I'll do what's best for the kids, with or without the consent of the parents. But obviously, 15 and 17-year-olds, the court's going to give strong deference to what they would like to have happen. And that might be to live with their dad, their mom, or to be independent. But go ahead.
Well, I guess I should like to testify now, I guess.
You'll have that opportunity.
Because I'm going to call him first before he does.
But do you have any follow-up questions for your client?
Well, yeah, actually, I do. On the expenses, Lisa, the stipulation doesn't waive your right to go back and get unreimbursed medical expenses, does it?
No, not that I'm aware of.
It just restated the medical and dental expenses. And at that time, you had specifically decided not to press the issue, probably because of Mr. Gadrew's response to it.
Right.
Is that correct? Okay. And now you do want the reimbursement to go back to 2007. It's not that far before 2008, correct?
Just bear with me 1 second. Go ahead, Counsel.
That's all right. Has Mr. Gadrew ever paid you for unreimbursed medical expenses?
No.
Ever?
Never.
I mean, since 2002 to present.
Never.
So you're not looking today because of how old they are to go back before 2007, but you are asking for 2007 to present, correct?
On the unreimbursed?
Yeah.
Yes.
And again, you're probably talking thousands of dollars of not getting paid from 2002 to 2007, correct?
It's two girls, yeah.
Overruled.
Okay,
Can I recross with what he just addressed, with those issues?
If you have one quick question on that, yeah, you may. But again, mother isn't requesting any back
Well, from
medical
2007
expenses.
she is.
Yes, go ahead.
Have
Go
you,
ahead.
have, you yourself just admitted under oath that you did not send me any invoices. Till when? When was the first time you sent
I
me an
didn't
invoice?
say I did not say that.
Okay, when did you first send me an actual invoice?
Actually,
I'm going to object because that goes out the scope of, hold on, of my redirect. It goes beyond the
I'll let
scope of it.
her, hold on, sir, don't turn around to argue with them, look at me. The objection's overruled, and if you want recross or redirect, I'll give it to you, but I'll let at least one or two questions be asked.
as a matter of fact, I sent you a letter with a copy of the ledger from in 2004. Is the first time I asked you to make payment. Is the first time I submitted that. I can't recall each time since that time that I have done so, but I have done so, and you know it.
No, I don't recall it. But
Well, again, it's not your time to testify, it's your time to question this witness.
And so, since 2004, have you sent me anything else?
Yes.
And what would that? What have you sent me an invoice? An invoice from an actual invoice, other than a list of what you say I owe. Have you ever sent me an invoice?
I've sent you a list of what you owe. Have you got an invoice? I didn't get invoices from Dr. Brigham. I had to ask for them to get a printout. I went in there, make my payment when I brought the girls in for their appointment. You know about the appointment. It's been ongoing since 2001. What am I supposed to give you? You've known about it from 2001.
Yes, and why is it? You obviously consider this a medical expense, and that's why it's unpaid because it's orthodontia. But it was ruled.
Okay, Your Honor, I'm going to ask that you now stop him because of time.
I'll let him
constraints.
ask one more question. We need to get both parties a chance to testify. I allocated an hour, but we started late and we had some interruptions, but we're now just about at an hour. Well, go ahead.
So, but the bottom line was you didn't send me an invoice. You said you sent me a list. Is that correct?
I sent you a ledger, yes.
I don't have any further questions.
You may step down.
Now I'm going to call Mr. Goodrow.
Mr. Goudreau, counsel does have the right to call you. When he's done questioning you, I'll give you a chance to cross-examine yourself simply by way of providing me with a narrative of what you think I need to know regarding the current issues before the court.
Okay, Mr. Goudreau, did you make a child support payment in the year 2009?
No, I did not.
Okay. Have you made one this year?
No, I have not.
Okay. Not $1? Okay.
No, I have not.
I'm going to hand you what's been marked as Exhibit 1. It's your financial affidavit, isn't it?
Yes, it is. I don't know if it's complete. Let me look.
Now, in the 90s that my client spoke of, well, let's strike that. Other than being, have you ever been employed for anyone else other than yourself?
Yes.
Okay. When's the last time you were employed by someone else?
1995, I believe. No, excuse me. Pacific Pulmonary in 2005, I believe it was.
What'd you do for them?
I was a manager for it's a pulmonary company, just a manager.
Okay. And how much did you make?
I believe at the time I was making $65,000 a year.
Is it the last full-time job you had?
I've always worked, sir, full time.
Is that the last full-time job you had?
For somebody else, sir?
That's what he's asking.
Yes.
That was for somebody else, yes.
Please listen carefully to my questions. Most of them are going to be yes or no questions, sir.
Again, though, hold on. You can answer questions completely, but just as I cautioned Ms. Goudreau to not try to speculate or figure out where you were going, answer only the questions asked of you, and don't volunteer anything else because you'll have a chance to explain.
Now, the $65,000 job, you said you were a manager? Okay. And what happened to that job? Did you quit?
No, actually, I was a sales manager and I didn't make quotas, so I was let go.
So you were terminated?
Yes.
Okay. Did you try to get another job in sales?
I tried to get another job in a lot of things, anything I could.
Have you been doing that the last 6 years, or excuse me, last 8 years?
I have been doing a lot of that. There is a period.
Well, isn't it true that you just gave up looking for work and what do you do now? You play your guitar for people?
That's not true.
What do you do, sir?
I do play guitar for people. That is my job right now because it's the only way I can eat.
And how long have you done that?
All my life.
Okay, sir. How long have you done what you're currently doing, working full-time, playing guitar, as you say you are?
I've always played guitar and tried.
Full-time?
Full-time if you can get it.
Are you currently working full-time playing your guitar?
What constitutes, sir? I don't understand the question now. What constitutes full-time? As often as I can play to get paid, I take the job.
What else do you do?
Right now I'm trying to bring back my parents' document business.
That's it?
That's a substantial amount of my time here. Yes.
Obviously isn't going well, is it?
It's not doing really well. It's not doing well right now, and that's why I'm there.
Are you making money yourself?
No. I try.
Why are you doing a job that you don't make money at?
I'm trying to salvage it so that I will have a job.
How long have you been trying to salvage it, sir?
I started working with them, I guess, trying to think about maybe 6 months ago, 7, 8 months ago. I don't know. I used to actually...
Okay, sir, what did you do before that?
Prior to that, let me think. I tried to develop a business called MedNet, where I did marketing for doctors and attorneys.
That didn't work out either, did it?
I had no financing to
So,
support.
sir, why aren't you working for someone else instead of trying to do your own business or trying to make
I think it's argumentative.
Sir, please let me finish. Instead of trying to resuscitate a business that isn't making money or trying to start a business on your own, instead of playing your guitar, why don't you get a job, sir?
Sir, I have attempted to get the jobs. I haven't got your education, sir. You have a law firm, do you not?
It's not up to you to question whether Mr. Viles is a successful lawyer or in bankruptcy.
Why haven't you gone out and got a job that pays you a salary or by hourly wage? Even go work for Circle K, something like that. Have you tried to do that?
I have.
Yes or no, have you tried to do that?
Sir, I make as much as that right now doing what I'm doing.
Sir, have you tried to get a job that gets you benefits?
Hold on.
Quit badgering me. Let me finish.
Have you tried to get a job?
You're being asked whether or not you've tried to get a job,
yes,
whether or not why you haven't.
Have you tried to get a job at, say, Walmart or in retail or something like that?
No, sir, not in Walmart.
Sir, it's a yes or no question. No?
I thought I said no.
Okay. Have you tried to get a job at a gas station or something like that?
No. Would you like to ask me the reason?
Sir, I'll ask you the questions I feel are relevant to ask you.
I know you will.
And have you tried to get a job in sales again?
Yes.
Recently?
Yeah, all the time.
How are you looking for that work, sir?
Through networking, through people.
You have any evidence today that you're doing that?
Yeah, I guess I would have some.
Do you have any evidence here today marked as an exhibit to show that?
No, I don't.
Okay. Fair to say that, well, is your only, where's your income coming from, sir?
From entertaining, from playing music.
Is that paid in cash?
On checks and cash.
Okay, so you're not so you don't claim all of your income, do you?
Your Honor, Yes, actually, you know what? I don't make enough to have to claim.
So you don't file, you haven't filed any tax returns?
No, sir.
What about bank account statements? You bringing those to court today to show what your income is and what your expenses are?
If you had asked for them as disclosure.
Did you bring them, sir?
If you had asked for them, I would have brought them.
So that's a no, right?
I didn't bring them, you didn't ask.
Is that a no, sir?
You didn't bring them, correct?
Didn't bring them.
Not
That's
whether
what I
or
said.
not you were asked to bring them, but you didn't bring them is all you're being asked. Nobody's,
Did you bring any evidence to court today in writing, anything in paper to show what you actually earn and what your expenses are? I'm talking about objective evidence, not your affidavit that you filled out yourself.
I don't think I have any of the things you're asking for. No, I didn't bring any.
And it's your testimony today that you, well, strike that. Currently, you rent a room from somebody, you say in your affidavit.
Yes,
How much does it cost you, sir?
$75 a week.
Okay. So what does your affidavit say it costs you per month, sir? Can you look at your
I
affidavit?
believe it says per week.
Sir, look at your affidavit and tell me what it says you pay for your housing expense.
That's what I said. Housing, rent, $325, is that what it says?
$325 a month is what I see, correct?
I believe I averaged a year to make it to.
You have a phone charge. It appears you have a cell phone. You have a cell phone, sir?
Yes, I do.
You have a cell phone, but you're not paying your child support. That's correct?
It's required in my job to.
Yes or no, sir?
Yes.
Okay. And you have a car payment?
Yes.
Okay. But how much is your car payment per month?
I'm 304, I believe.
Okay. So you pay that car payment, but you're not paying for the child support. Is that correct?
Yes, that is
Okay.
correct.
All the expenses that you have listed on your affidavit, you're paying those every month. Is that correct?
I don't know if every month I haven't looked. Let me see. You know, some of them are subjective, you know, meals and such.
Well, but you're eating, aren't you, sir?
Not good.
You're eating, though. According to your affidavit, how much are you spending per month on food?
It says about $60 a week.
What is it? What's the total there that you have there, sir?
It says $260.
$260 a month. You're spending $260 a month on food, but you're not paying your child support. Is that correct?
That's on everything. I mean, food, milk, lunches, everything.
All right. Let's talk about. Well, you don't deny then you haven't paid
No,
for 2009 or 2010, right? You don't deny that.
no.
And you didn't intend to pay it in the future, did you? Yes or no?
I object to the question.
Well,
May I object to the question?
what's the ground, sir?
It's just argumentative. Do I ever
Well-
plan to pay in the future? I love, you know, I love my girls. They can have everything that I have,
Okay, but Your Honor,
whatever it
okay.
is.
you
The
have-
question is whether, again, it's somewhat speculative, but is it your intent to bring your, to make your current child support payments from this
Not what
day
he asked.
forward?
let me ask it that way, sir. Do you intend to pay your child support this month?
I haven't the funds to do it. If I did, I would.
Do you intend to do it next month?
If I have the funds, I will.
In
And
fact,
I've already filed, as you know.
You're not paying
Custody.
because you don't think my client should receive support from you. Isn't that true?
I'm not.
Yes
I
or
don't.
no?
No, that's not true.
Okay.
How's that?
Your failure to pay is malicious, isn't it?
No, it isn't.
And my client has given you notice of these expenses, hasn't she?
No, she hasn't. Not until.
And you've known when you're aware that the children were going to Dr. Brigham for orthodontic procedure, correct?
Yes, I am.
Okay, so you know that. In fact, your name is on some of the documentation, isn't it?
Not that I'm aware of or was aware of.
But you could go down and find out yourself. You know where Dr. Brigham is, don't you?
Yes, I do.
You've taken the children to Dr. Brigham yourself, haven't you?
Yes, I have.
So you're aware that these orthodontic expenses have been incurred over at least the past 2 years, right?
I'm not aware of how often you're going.
Well, you're taking the kids there. In the last
haven't.
2 years, you've taken the children, haven't you?
I don't believe I have.
How about the last 3 years?
Maybe I'm not.
And you're aware that they're getting this work done, correct?
I'm not. Yeah, I'm aware of the work. I'm just not aware to the extent of what work.
And you haven't objected to it, have you?
Yes, actually, I have.
When? Do you
From
have
the
something in
initial-
writing, sir, that
If
shows?
you ask me the question, I'll answer it.
Sir, do you have something in
ask-
writing that
One at-
shows you
one at a
object?
time.
Do Do you have something in writing here today that shows you objected to the orthodontic expenses?
Here today.
Yes, here today.
Not here today, but I have objected as
Thank
you
you.
asked, and I will
Thank
answer
you,
your
sir.
question.
One at a time.
Okay?
Thank you,
May I
sir.
answer your question? Have I
You have
objected?
answered my question.
Let him finish his answer.
Yes, I have objected in court before.
How long ago? 2005?
From the initial time when we first went.
You don't think your
to
children need orthodontic work, sir? Yes
Sir,
or no?
Are you going to let me finish answering the
Yes
question?
or no?
Hold on.
Do you
Answer the
think?
question. You
Okay.
asked me.
Here's my question. Do you think
You
your
asked-
children need orthodontic work or not? Yes or no?
I don't know to what extent they need it, but that isn't the reason. Oh, my God.
So is it a no?
Restate your question.
You haven't paid a dime for any of their medical expenses since 2007, have you?
I'm not aware of any, until recently, any
Have you paid?
medical expenses to pay.
Have you paid any on their behalf? Have you taken them to the doctor? Have you taken them to the dentist? Yes or no?
Actually, I'm sure I probably have taken them to the doctor when they were living with me, yes.
Okay.
You know, for minor things.
Have you paid any of
Yeah.
those expenses? Well, how
I
much have
would've.
you paid?
Sure I would have. I mean, I wouldn't have thought of anything else.
And would you expect her to reimburse you for those things if you'd
No.
shown her? No, you don't think so.
No.
You think it unreasonable to expect you to pay your share of the expenses, yes or no?
Not at all.
Yes or no?
I said no. Not unreasonable.
Your Honor, I have nothing further.
Okay. Now is your opportunity to go ahead and explain to me what you think I ought to do with respect to Mother's petition to hold you in contempt of court for the alleged willful non-payment of child support, and what do you think the court should do with respect to Mother's claims for reimbursement regarding uninsured medical expenses?
Your Honor. The amount of monies that she claims I owe for the uninsured expenses, I really I don't have any real documentation as to what she claims or doesn't. But, sir, if I have anything, I'm willing to give it to my children, anything and everything. I'm not in a position and haven't been for a while, as she knows, to contribute. I try instead to contribute in a way with my children, with church and those kind of things, to stay involved with them. It's my testimony that the reason that we're here today is not because she needs money. It's because she's concerned. I guess as I'm testifying, I can actually finally say it or whatever, that I have discovered monies that were taken. And it was enough, sir, when she talked about the business.
Objection relevance.
I'm going to let him finish. I understand that may be pre-decree matters, but I will let him tell his version of events to the court as an explanation as to why he thinks that child support shouldn't have been paid.
No, sir, Your Honor.
Go ahead.
When the business failed from our marriage, it's been a constant struggle for me. Constant struggle. And like I said, like you said, I always say, I'm doing my best. I'm 58. I'm not degreed. If I were in a position pay, I would be paying, and then I would be doing the correct things. You asked why I didn't file against her, is because when I do file, Your Honor, I get a year or 2 years of this kind of litigation. If you look at our records, she's filed for custody before for the children, and that's why we have a parenting coordinator. It was just draining. I have not willfully not paying anything. I mean, if I have anything in my pocket, it's my girls. I would never not willfully pay anything, and that's what's being alleged here, and it's completely wrong.
Well, let me ask you this. If you didn't have income earning potential, why in 2008, July, did you agree to pay not only $200 a month for current child support, as well as $200 a month toward any arrearages?
Yes, sir. Because, Your Honor, I had just previously lost virtually everything that I had. I mean, I lost a house, lost a car, the repossession. The business, my family business, there was issues there, and I was basically trying to reestablish myself, coming back into Phoenix at that time, and she was well aware of this when she filed the papers for modifying custody and support, and it was a matter of, I was more concerned, and emails will actually support this if I ever get a chance. I was more concerned about my children and being around them because she was going through serious problems with her marriage. My daughter had been running away. I was trying to establish myself back here in the valley so I could be there for my children, which I did. I actually took an apartment near to where she lives so I could be there for them.
Again, though, my question is why would you have agreed to pay $200, actually $400 a month toward child support and child support arrearages in July of 2008 if you didn't have the ability to do it?
No, and I did pay that amount at the time. I had basically gotten a job as a contractor marketing for a company, a law firm actually, and I had expectations of being able to keep that. However, the law firm, they lost their budgeting for any kind of marketing, and so I was let go. I didn't anticipate being let go as soon, and so I did that based upon what I thought I could actually afford, and did it until I couldn't afford, until I lost the job. It was tough. To be actually the $400 from what I was making was actually tough at the time, but I was more concerned about getting there and being there for my children, and that was my primary concern. And so I was paying that, and it was also, Your Honor, there was my primary motivation for doing it was to be, like I said, to put myself in a position where we wouldn't be litigious, we wouldn't have any of this. I could just raise my children, you know, as supposed to be raised. That was my primary. But I was also very much, and you'll see emails that go back and forth where it's, I'm going to throw your, you know what, in jail if you don't do, and
I guess my question isn't whether Mother has been kind and gentle in her relationship with you. It's a question of whether she's wealthy or just of modest means, why she should be paying 100% of the costs for food, clothing, and shelter of your children, education of your children, and medical care of your children.
And actually, you're absolutely right. She should never pay 100%. However, Your Honor, this is all stemming, as I said, from my discovery that a sizable amount of money was taken from the estate, which is actually the beginning of my struggles to earn money. It closed my business, and I've been fighting ever since to try and get my head above water. I really have. I'm not a lazy person. I work. I want to work. I want to provide for my children. And I always did so, but at the same time, she doesn't believe that she would ever have to pay me support, and so that's why I was alleging, and I can show that, for example, just a month prior to filing the charges against me for contempt the first time and to get custody of my children, she had bought her cottage and put $120,000 down on it.
But again, even if she's a millionaire,
Yes.
Which she's not, but even if she were, why should she be saddled with paying 100%? $200 a month of child support for 2 teenage children is probably below the level that someone earning minimum wage would be required to pay for 2 teenage children. And but for the agreement, your child support obligation would probably be higher even if we imputed minimum wage to you. And my concern really isn't whether you could pay the full $200 or $400 a month, but the fact that I'm looking at our clerk's official records that show that there was not a penny of child support paid after December of 2008, nor was there any petition seeking to modify the amount of agreed upon child support based upon a substantial and continuing change of circumstance.
It was,
and I'm talking about I've had fathers that really did have, or mothers that really did have a hardship situation, but they're paying $25 or $50, or they'll occasionally pay $500 and then maybe miss a month, but they're making a good faith effort to seek and maintain employment and to pay what little they can toward their child support.
Your Honor, it's hard for me to explain the level of destitution. I don't get care when I need it, as far as my physical. It's like I'm right on the edge of the whole time, right on the edge. And Your Honor, had she not coerced, and I use that word coerced me into, I would have taken my children and they would have lived with me. However, she would have paid me support as I did her for years. Even though we had 50-50, I was paying her child support, Your Honor. And I don't know why the difference would have been why she shouldn't have supported me at the time when I needed to.
Okay, Your Honor, I'm going to have to object at this point because
again,
all of this is irrelevant, really.
Again, when I have parties that have equal parenting time, sometimes mother pays father, sometimes father pays mother, and it's dependent upon the disparity in their income. And if there was a change in mother's or your income, it was incumbent upon you to seek a change or modification of child support. Go ahead.
We have, if you look at our history and our record here with the courts, it's constant. I mean, I've been in court constantly, and it's.
Your Honor, he's just wasting our time now. I'm going to object.
Go ahead and wrap it up. Go ahead.
I thought I was actually answering your question. Right?
Go ahead and answer my question.
It is my goal, Your Honor, to be a father to my children and to provide for them. And I believe that it is her goal, and the way she has attacked me through the different courts, different things, to make sure that doesn't happen. Sounds harsh, but if you look at the history of our records in the court, that's what it's come down to. And I spend a lot of energy, just like right now, Your Honor. I want to put myself in a position where I have a home and I can bring my children. And I'm working towards that right now, and that's what I'm doing with the family business, Your Honor, and she's well aware of the potential. There was an altercation between myself and my family. basically, I've come back to try and salvage the business. I believe that I can. If left to doing that, I can salvage it and become in a position. It's the best opportunity that I have to make enough money to help with my children is what I'm doing right now, Your Honor. And I'm working hard at doing it. And I'm actually working the extra with what I play actually helps. It just pays for my living right now while I try and do this. And it's basically my mother will retire. It's her business, and she will retire, and I will have an opportunity to run it. As I said, with the way that it should be run, and I think it can make money. It can make enough money, and that's why I'm working so hard at it. But I have never, ever not made an effort.
Okay.
It's just been extremely difficult, especially the last couple of years, Your Honor.
Okay.
To get back. I mean, I'd have never believed it in myself. And it is my intention to file anyway regarding the assets that we're talking about, either with this court or with the civil court or wherever I can, I have to figure these things out myself. Because she does owe me money that she's refusing to pay, and it just goes to show the character, Your Honor, of the money, whether it was an issue.
Jackson, he's gone over this already, Your Honor.
No, actually, I haven't testified to it.
Yes, he has.
She has taken the money, and the fact that she's here now and hasn't paid me goes to her.
Well, again, I haven't this court hasn't in the 8 or 9 years since the parties were divorced been asked to enforce the decree. There hasn't been any proper motion ever filed to set aside the decree because of fraud. And there's no evidence to suggest that evidence that was newly discovered through the exercise of reasonable diligence couldn't have been previously discovered and presented to the court at trial or shortly thereafter. But do you have any follow-up questions of this witness?
No, Your Honor.
Anything else you wanted to say?
Just that my intention is to do exactly as you say, Your Honor, and file with the court, and I had newly discovered evidence.
Okay.
And yes, I do, and I will.
All right, you may step down. Thank you.
No.
Anything further other than closing argument?
No, Your Honor.
I'm going to give you, counsel, an opportunity to summarize your client's position, and then I'm going to give father a similar opportunity.
Thanks, Your Honor. Look, if anybody's been willful about not paying child support, I would argue that it's Mr. Gaudreau. First of all, you pointed out that the amount isn't much for 2 kids that are teenagers. Then he has, since the end of 2008, not paid a dime. I mean, he hasn't paid $5, $10, $20, nothing. And you've seen his expenses. His expenses well exceed the support amount. He could have paid at least $100 a month, something. And then there's the issue of why he's in the financial position he's in. If that's going to be an issue to argue against willfulness, I would argue that what he is doing, he's purposefully keeping himself from earning the kind of money that he could, it seems, so that he, in his mind, doesn't have to pay my client back. He earned $65,000 as late as, I forget what year he said.
2005.
Yeah, and, look, the economy's tough on everybody, but why can't he get a job that makes $2,000 a month if he could make $65,000 a year when he last did? He's choosing to live the lifestyle that he lives, and it's at the detriment of the children. And if you want to really look at how contemptuous his conduct is, look at the exhibit for the email here, Exhibit 5, where it says, let's see, if you pay me the money you owe me, then I can catch up on the support. If you pay me what you stole, I can retire. I've had enough of your crap. See you in court. That was his response to her asking him to pay before she filed this petition.
Your Honor, that is,
This petition to enforce.
You'll get a chance to argue or summarize your position in just a moment, sir.
I mean, he's paying rent, he's paying a car payment, he's paying for a cell phone for himself. He's working basically in a cash basis, so nobody really knows what he's making. He didn't bring any bank account statements to show you what he's making. He's got no tax returns. He's doing all he can for us to not see how much he makes. I would argue that his expenses probably exceed what he's put in his AFI, but how would we ever know, because he hasn't given us any information. And then he claims he's fighting to get his head above water. He's really not giving you any examples how he's doing it, other than taking over a business that's making no money and hasn't made money apparently for a couple of years. And when it comes to the expenses, although my client didn't follow the letter of what you had suggested, Mr. Gaudreau sat there and told you that he's taken the children to this orthodontist. He was aware that the orthodontic work was being done. He didn't deny that the kids needed that work. And although he said a couple of times he's paid for medical expenses, clearly my client is the one who's in charge of getting the orthodontics done, getting the dental done, getting the medical done. She's in charge of everything and paying for it, and then when she comes to get her share of it, he hides behind, well, I don't know what's going on, or I don't know what the costs are. And the costs in Exhibit 6 are reasonable costs for the time period we're talking about. These children, they're 2 teenage kids who are getting braces, plus there's these other expenses for medical, which aren't high, and for dental. Most teenagers incur those expenses, and again, he's been aware of them. He hasn't objected to them. And to hide behind, well, she didn't disclose this, or she didn't do that, or he knows Dr. Brigham. He could have went to Dr. Brigham and got a printout himself. So he's disingenuous with us in the court. He's wasted the court's time today filing frivolous motions, giving you frivolous testimony about things that really aren't relevant, and in his own mind aren't provable or have any legal basis. And you should put him in jail today, Your Honor. He needs to go to jail, because if you don't put him in jail, he's not going to pay anything. And the purge payment should be all of the payments he hasn't paid since that date, $200 per month times 18, and I think that's $3,600. If he pays the $3,600, then he can get out of jail. But he should go to jail today, and he should also pay attorney's fees. And we're asking that you enter an order for the medical expenses for, I think that the testimony I recall was $6,751 for orthodontic expenses, $140 for medical, and $1,069 for dental. Thank you.
And is that 1/2 of those expenses?
No, those are the total.
Okay.
Half of that.
Sir?
I'm not addressing whether the children need orthodontia. I'm addressing whether or not it was my responsibility to pay because of the contract that she had signed, which is addressed in another court at another time, and it was decided that I didn't owe it. And that's one. I mean, I think my children need orthodontia. She was in a position where she wanted to pay for it, and she did. I'm not good at this except for to say. You have to give me a second. I feel strongly that I need and would have needed counsel here, which I don't. And the motions that I asked to get counsel and the efforts that I've made to get counsel, Your Honor, were unsuccessful. wholeheartedly. However, I will say that the reason that I can't support my children, and I believe strongly with the evidence that I have uncovered, is because she took enough money to put me in a position where I couldn't, and is using that money and has used it systematically since our divorce to continue to attack me with it. Even as such, I mean, like I said, I agree it's my responsibility, but I don't believe that I'm willfully hiding anything. I know I'm not willfully hiding anything. This person here seems to think that he doesn't have to follow any of the rules of court, which would allow me to have actually maybe an understanding of what today's hearing would have been about, or prepare better for it. But when he hands me things the day before the hearing, or it says May 5th deadlines, and he gets it to me by the 28th of the month instead of the 5th of the month, and I'm scrambling just to breathe, to try and figure out what I have to do or how I can do to respond to these things, Your Honor. It's just it's basically it's as far as this is concerned, Your Honor, I'm not making any extra money. I'm not hiding any extra money, as he contends. Anything that comes out now, I mean, for example, Your Honor, I mean, I've got severe dental, to the point where it's difficult for me to eat. If I'm not a masochist, if I was making the money to fix my teeth, I would. She's well aware of these things, and it's not as if I try and hide from her or hide from my children. I try and stay involved in their life. This is just part and parcel of what of her. As I said, I believe that I wrote it up and I sent it down to you, where it says that this is systematic. There is a system. There's a history of custodial interference. There's a history of me being assaulted by her friends or boyfriends. It's just a constant comment at me the whole time. And finally, it's just got me to the point where I'm struggling so hard just to provide. I mean, to provide for myself. And that doesn't mean I don't feel I need to provide for my children. I do. I feel it's serious. It breaks my heart. That's what I'm saying. But when we go to motivation on her part, it's not. I'm not saying that I shouldn't help provide, but it's not because she needs money. If you look at her finances, just the opposite, as a matter of fact. And like I said, I have recently discovered some things, and this isn't the court maybe to have the ruling in. And this will be addressed in future proceedings, Your Honor. If I can, putting me in jail isn't. It's not going to. I mean, my God, it's not going to help me find a manner to pay. I am actually in a position right now, Your Honor, where my family business has been there for a lot of years. There was a period of time when I was trying to take it and make it work, and then we had an altercation, a fallout, and actually through the courts. And I had to leave the business, and that's really that hurt me a lot. I came back now just recently, and I'm building it back up again. And I honestly kind of believe, Your Honor, that as you see the things that I'm doing here, that is doc prep and doing those kind of things, that I'd be good at it, and that I can build it back, and that I can make a difference. I don't do much more than I would do working at a Walmart or making $2 an hour. I can do more for my children, and that's my goal. I've never limited myself to the efforts that I put forth, and I put forth extreme efforts. I mean, extreme efforts, and I will go without myself if my children need something. I just said. And even though she makes it sound like I don't give them anything, I try and give them what I have, and I do. I go to church with my girls. I do these kind of things. I try and be involved in their lives. If I can help them get something, I'm sorry that I can't afford to pay for, like I said, she gave me a bill for $3,000 in 3 months as my share of their clothes. And I can't do that. I don't have the money. But I'm working towards having the money, Your Honor. That is the God's truth. I am working hard right now, and I believe in my heart that I will. The things that I'm doing now will make a difference, and they will put me in a position to where I can pay. I guess I think that's the gist of it. I don't get many opportunities at this age, as he said, to go to work for another company. I tried working for another company, and sales has never been my forte. Marketing maybe, but there's not a lot of people looking to hire me out there, and I did make huge efforts. And this now, to be able to go into this business and actually have a potential and to make it work again is the best thing that I've got. By far the best thing that I've got and the best potential that I've got to come back and actually make a difference. I can do the same thing with it that I did with my chiropractic business and expand it through professional service agreements. I've got plans that I'm working really hard on. And I will be successful at it. But I think I spent the last 3 months, it seems like, doing more of this than doing that. If you give me the opportunity, Your Honor, honestly, give me the opportunity to start making a difference, just maybe a few months, and I will start being able to pay. And that's not in a position right now where I would. I'm not so stupid to think that I couldn't. If I could give her $50, I can give her $50. But to be quite honest, I need more than that with just my teeth at this point in time, and it's affecting my health. Okay.
Thank you. I feel compassion for husband, Mr. Goodrow, because I think that he is financially struggling. But I also think that he understands the legal system far better than many pro pers, as is evidenced by the pleadings he has filed in this court and his at least cursory knowledge of the rules of family law procedure. The parties, by agreement, on or about July 22nd of 2008, in lieu of going forward with an evidentiary hearing, stipulated and agreed that father would pay $200 a month as in for child support for his 2 teenage children, and an additional $200 per month as and for child support arrearages. Unfortunately, there was no calculation or stipulation or agreement with respect to child support arrearages that were in place as of July 22nd of 2008, and there may have been other things the parties agreed to, but there was no waiver of arrearages by mother. In fact, there was an affirmation of arrearages even though a judgment amount was not entered, which would make it, unfortunately, somewhat difficult to calculate when father's arrearage payments had been paid so that he was only paying current support. But the records of the clerk of this court, and I don't have the Family Conference Center's report, as was ordered. I believe it was our error in not endorsing them on the minute entry, even though I had ordered it. But I'm not here today to decide what the arrearages are prior to prior to July 22nd of 2008. But I do find that current child support from August forward, so 6 months of child support should have been paid in 2008. And, well, let me just make sure. Just bear with me. From August 1st through the end of June, father should have made current child support payments for 23 months, or a total of $4,600. He has made 4 payments of $397.50, or a total of $1,591, equal child support arrearages without interest being calculated from August 1st of 2008 through June 30th of 2010, with credit for the payments that were made. And while he was only required to pay $200 a month, the $1,591 in support payments made in 2008 will be credited as against current support and not against arrearages, because that takes priority over arrearages. So from that time frame referenced, father owes $3,009 as and for current child support arrearages. And I'm going to enter a judgment against him for that amount. I do find that his non-payment of child support for the last 23 months, it's actually longer than that. Well, for his non-payment of child support is willful, because he hasn't presented any evidence to this court as to what jobs during the last 2009, 2010 he has applied for. And I know the economy is tough, but he could have presented evidence to this court, even though he complains the other side disclosed nothing to him. He's presented nothing to this court to support his affidavit of financial information. He's acknowledged he hasn't filed tax returns claiming insufficient income. No, and yet he's able to live and pay for his car, pay a nominal amount for his rent, but he manages to live. And he is sophisticated and intelligent enough to know that if his income was lower than that which would have supported a $200 a month child support payment and a $200 per month arreared support payment, he had the knowledge and experience to file a petition in 2009 at any point in time to modify his child support consistent with his income. What's disturbing to me is he has paid nothing in all of 2009 and 2010. And even if mother robbed him blind at the time of the divorce, that has nothing to do with his current obligation to pay child support. And there's no competent evidence before this court, nor was there any at the time of the divorce decree, that either party had wasted community assets or had robbed the other party blind, nor is there evidence that it was newly discovered evidence, which reasonably, through the exercise of due diligence, couldn't have been discovered prior to the divorce trial or prior to the 2008 settlement in lieu of the hearing. And accordingly, this court finds that the willful non-payment of the $3,009 has been willful because, again, father has not demonstrated that he has been seeking gainful employment. And candidly, I'd rather see somebody flipping hamburgers at McDonald's or working as a greeter at Walmart than claiming that he or she is working on the family business. I don't have any evidence as to the gross income for that business over the last 2 or 3 years and its expenses, but clearly I have no idea whether there have been good faith efforts to make that business a success, and if so, what those efforts have been. And that's not the result of mother's failure to disclose information. It's the result of father's failure to bring competent evidence other than his testimony to this court. And if he had been paying $10 or $20 a month and had evidence of what his earnings were and that was consistent with those earnings, I would think otherwise. I'm going to set a purge. I'm going to take him into custody at this time in order to be released, he'd pay a purge payment of $2,500 a month. And then immediately upon his release from custody, he begins to pay at least the $200 per month as and for current child support. And I am also going to enter a judgment against him separate and distinct for this. I'll take a review of it again, but I'm of the belief that there are $3,248 from my review of Exhibit 6 in unpaid orthodontic expenses from August 1st of 2008 to the present. The parties had the ability to litigate prior medical expenses and reached a comprehensive agreement in July of 2008. So I believe there are $3,248 in expenses for orthodonture from August 1st to the present. I'll recheck that, plus $140 in unpaid medical expenses and $1,069 in medical expenses. There's a total then of hold on. In $4,457 of unreimbursed medical expenses, if my arithmetic is correct, from August 1st of 2008 through the present, and one half of that amount is $2,228.50. So I'm going to enter medical reimbursement order in the amount of $2,228.50, and I'm going to order that mother will present in the future father with actual bills from any healthcare provider, proof that she's submitted those bills to available insurance if there is any, and then proof of what she has paid out of pocket within 6 months of incurring any medical expenses for the children, and father will have 30 days after receipt of mother's proof of payment of those charges to reimburse her one half of those medical expenses. And I would urge that with ongoing orthodonture, that's known, but I would order that mother advise father in advance of incurring any dental or medical experiences except emergency expenses, that she notify him in advance of any visits or scheduled appointments with healthcare providers sufficiently well in advance so that father can attend those appointments with those healthcare providers if he chooses to do so, or confer with them by telephone for purposes of conferring or confirming the existence of those charges. There's going to be no purge on the medical expenses, just a judgment, and a judgment, as I indicated, for the $3,000 and change for child support arrearages with a purge payment of $2,500 to be released from custody. I will deem father eligible to participate, not in the work release, but in the work furlough program if he's deemed eligible. And I am going to set a review hearing in about 30 days. If father has made that purge payment, we'll have him here voluntarily at the next hearing. Mother and her counsel may appear by telephone if they wish to. If father is in custody, he will be able to attend that hearing by phone if I can't have him transported here. But those are going to be the orders of this court. Any questions?
Just on the attorney's fees issue?
I'm going to take the issue of
Under
attorney's fees
advisement?
under advisement.
Okay.
Have you? I'll ask you to submit, though, an
China doll?
affidavit of an application for attorney's fees supported by proper China doll affidavit, or supported by proper affidavit. I'll keep the China doll out of it, but that's the case we follow regarding those affidavits. Yes, sir?
I'm not any kind of a risk as far as, I mean, obviously the plea or anything, I would never, I'm here. Is it possible, I guess, to allow me to get some things in order before I'm reprimanded, or I'm not at risk to plea.
Well, I'm just ordering you incarcerated immediately, and if you can make arrangements with your family or friends or your bank to get that $3,000, you won't even be booked. Most fathers or mothers that I set purge payments for are able, usually before they're booked, to come up with a source for those monies, and the sheriff will probably hold you for a while to give you a chance to contact family members or friends to pick up any of the documents you've brought here today, and or to come up with the funds necessary for your release. This matter does stand in recess.
So you know, I will be contacting the police on your record. didn't want to turn you over to the police that way. This is what I'm having to experience because of what you've done. I am. Yeah, I'm trying. Oh my God, I can't believe this. With mine. That was one of my court documents, wasn't it? I had some with that on it.
Yeah, everything with a green sticker, you gotta stay with the court.
But I had some green stickers that I had from other court hearings. And that's what I was saying. Oh my God, this is just absurd. Oh, excuse me.
So I understand, have a seat. I understand we call an ambulance for you?
No, I'm all right.
Dead.
Give me a second, please.
Right there.
No, actually, I think I'm better right here, just for a second. Just for a second.
I understand if we call an ambulance, you're gonna be going to the medical ward of the Maricopa County jail.
No, I know, I just needed to, I just got dizzy for a second.
I understand that. You diabetic? Huh?
No.
Okay. Is it okay if I just stack this like this? Sir?
Yes, sir.
All right. I'm just put this all in the form. So
Yeah, that'd be fine, don't worry about order or anything, so.
you know, that paper, I won't mess up with it.
Oh my God.
What we'll probably do this paperwork, sir, is if, with your permission, we're gonna put it in your car, okay?
Yes, sir.
That way you don't lose it, it doesn't go anywhere.
Thank you, sir.
What kind of car do you have, sir? What kind of car do you have? Any other,
It's out trying to say,
Any other-
dark blue stop.
any kind of other property you wanna put in the car?
Any jewelry or anything that you have?
To make things easier, do you?
I mean, I need my wallet, I guess, so.
What-
Am I gonna be allowed to make calls, or how's it gonna work?
Do you have anybody that can bring $3,000 up, $2,500 up here in 30 minutes?
Oh, in 30 minutes?
Mm-hmm.
I can make a call, but I don't, man, I tell you, my mother, but I don't know how she would
It's gotta
do
be
it.
cash.
If they can't get it here, they can always bring it down there, or up here after you're downtown.
If you don't think they can come up with it like 30 minutes, because we already got a van coming up here, we can let you make some phone calls to make arrangements for them to go downtown and pay it, and as soon as it's paid, you'll be processed to get out. How's that sound? Does that make sense?
Yeah, I don't have that kind of money, I think.
Are these reading glasses, or do you wanna
No,
take them with you?
they're reading.
Are they with you?
Yeah,
So, this deputy has your permission to go put this in your car? Where's your general location?
Right, in the front, it's a dark blue stop.
Dark blue stop.
Dark blue stop,
Four door, three door?
it's a two-door, it's got a convertible top, it's an older, you can't tell with the stop, though, so.
You just,
The battery's weak.
Is it facing the building?
When I parked, I think it's actually facing the other way on either the first or the second row. You know, as you go out.
About how many cars?
And that's what I'm saying, the first or second row as you go to the cars. I think I said in the first or second one facing,
Okay, so you're real close to the building.
yes,
you have a cell phone?
yes, I do.
It's
Is
not
it in your pocket?
Yes, it is.
All right, well, when we get back to our office, I'll let you start making phone calls.
Thank you so much.
You okay to walk?
Yeah, I think so.
We got a phone you have.
Pardon?
Got a phone you have.
Just a ticket.
All right, to walk? And then go out to the place.
Oh, okay.
You diabetic now?
No, I don't think so.
All right, like I said, if you didn't call an ambulance, you're gonna get the fast route to jail with no phone calls, because what's gonna happen is they're gonna take it to county medical